Folks. I am Johnny X-Ray, and I am here in the nation's capital in Washington, D.C. It is our intent today to go live over in front of the Supreme Court. We're going to be doing a follow-up with Audra Morgan out of San Diego, California. We'll be broadcasting from coast to coast, as we often do. For those of you who were here around the time of the California Family Rise interview with Michelle Donchan, and the call to action that started in Napa, California, outside the courthouse. It went to San Diego, and then on to the state bar in Los Angeles. And those connections that were made during that time have continued on to the present. And we conducted interviews from San Diego to the Supreme Court when I stumbled upon what may be an alternative path. Many times I bumped into folks who were coming into DC, and I would link up with them, and they were here to file, for example, a writ of certiorari, aka a writ of cert to the United States Supreme Court, or a writ of mandamus to the United States Supreme Court. Folks had converged on DC for what they believed was going to be a tipping point for their voice to be heard, whether it was for the We the People writ with Barbara Stone. There was I think it was the We Shall Be Free, where they were asking for people to sign affidavits, and that there was a requirement of 500,000 affidavits, which if you add up the weight of just one piece of paper times 500,000 comes out to 20 tons or maybe 20,000 pounds, one of the two. Either way, that requires a commercial driver's license and a commercial truck. If it's just one page alone, but how many people can consolidate the complex narrative of their their suffrage into only one page? So it just didn't seem tangible. But there were people that were saying, "Hey, there's more to this. It can be done. There's things that can be done that are tangible and could potentially be effective, but there has to be a better planning." And then it continued on to things like I think the Family Court, the FC, whatever that Justice and Accountability Act, and there was another diaspora of people that converged onto DC, and things weren't entirely what people expected or anticipated, and they left feeling unwhole. Some people actually dived further into destitute as a result, because they dedicated resources that were their bills, their mortgage, some sacrificed time that was both like visitation time, because they felt that it was important to come here, and with the hopes of getting their story out, and that they would have audience with elected officials that could potentially do things. And that's not to say that there aren't things going on in places with people, what I call a profile and courage. If you know what a profile and courage is, that's an actual thing. That's not just like a cool statement. A profile and courage has to do with the book that was written called Profiles in Courage, and that's what it speaks about. It's folks who are elected officials who have the power to make a change and have made decisions that went against their constituency or what their constituents wanted. And the book, that's what the intent of the book is to show people that sometimes they have to go along to get along as a means to achieve the things that we as constituents want. And it's hard to please the constituent bases because we want 10 out of 10. We want it right now. And politicians were trying, and that book's intent was to show people that that's not always going to be realistic. And some people have made decisions based on the intelligence that they're afforded that we are not as just common folks. And they made a decision that was they expected to be in the best interest of the people, but they sacrificed their careers, but later were determined to have made the right decision that was what was necessary, and it was for the American people. but as a result, their careers were devastated. So that's what a profiling courage is. And with the power and the money that's disseminated based on this harm, its motivation is clearly monetary. Um, that's an uphill battle. And so to find somebody or somebodies that are willing to say, no, no, this is not okay. And we're going to roll up our sleeves and go to battle. It's important to find those profiles and courage. And so surely there's people out there that are diligently trying to change the law or put forward legislation. There's already legislation. We have the United States Supreme, the Constitution, the supreme law of the land. And unfortunately, it's being cast aside. And there is the United States Supreme Court that has the power to undo some of these lower court rulings, but it's next to impossible to achieve an audience with the Supreme Court. You have a 1% window, and that 1% gets even smaller because of other obstacles that may be in the way. Just to file a writ of certiorari, the costs, even if it's IFP, which is in forma pauperis, or if you're going to pay the filing fee, we have several parents that I've met along the way that we're working together. We have all filed to the United States Supreme Court. We've established jurisdiction through the proper means. We filed an appeal. We submitted our appellate briefs. We responded to the appellee's responses, and then we responded to that. We've gone to oral arguments. We're not attorneys. We're just regular people. But once you get that denial from an appeals court, and then you file a request for review to your state Supreme Court, you can now, the Supreme Court of the United States then properly can take jurisdiction. That's when the next challenge comes forward. You've already weathered all the other challenges that are put before you monetarily. That lack of acumen is just being a regular person. But these people are picking up the torch and they're running with it. They're fighting and they're making some damn good arguments, man. I'm proud when I see these people, when they take up this task as people who are not qualified attorneys. They're just parents or litigants that are desperate to find some kind of redress. It's a beautiful thing to see these folks given the business to people. It's like going into a ring and fighting somebody. You're not a fighter, but you go in there and you fight somebody who's a seasoned veteran fighter. The courage that it takes. And then if you went in there and gave a dang good fight, maybe you even outperformed that other individual. That's the equivalent of what we're seeing with these pro se litigants, these parents that are determined. And linking up together and sharing information and what goes right and what goes wrong has been helpful. So the last time I interviewed with Audra Morgan, I was in front of the Supreme Court. I had found a different path. And people say things on these platforms. And one of them was saying that there's another way. So whenever somebody throws me a bone or some kibble, I go check it out. But before I relay it to other people, and that's unfortunately I've seen that as a flaw. That a lot of times people will hear something here and it sounds good, and they just immediately start regurgitating it and disseminating it without seeing if there's any merit to it, because it just sounds like it's effective. And unfortunately, then a lot of people are spinning their wheels. So it behooves any pro se or pro per, whatever you want to call it, sui juris, people that are fighting their own fight. Before you disseminate that information, you should see yourself and band together with other people to ensure that you guys have navigated that tempest to see if it leads somewhere proper before you say, hey, do this X, Y, and Z. So that's what I did. I went into DC. I went to the DC court. I went upstairs, downstairs, left, right, went up to Senate, went everywhere. And I was telling Audra and the other folks that I may have found an alternative. And at the time, I didn't know that you can also file a writ of certiorari at the end of a federal action. So if you prefer federal action in a court and you are not made whole, you can you work your way up to a writ of certiorari to the United States Supreme Court through that way. So if you haven't navigated the appeals process in your state and worked your way all the way up to the Supreme Court of your state and received an in-bank, a remitter, whatever, denial, in federal court, that's an alternative path. But I am actively now engaged in litigation in the U.S. Capitol. I've filed my writ of certiorari now to the United States Supreme Court. I've filed a writ of mandamus enter writ of habeas into Washington, D.C. District Court, and have requested a consolidation of those two matters. I filed a 42 USC 1983 civil RICO out of the Eastern District of Virginia, which is active and we're rocking and rolling. I'm not an attorney, and it's a complex dynamic. The opposing parties are represented by not just attorneys, but what's called super attorneys, like super lawyers. And in order to get, that's a real term. It's not just like a little funny thing to say. Attorneys that have certain accolades are can put that stamp on there that says we're super law firms. They have to have a certain amount of wins and things of that nature. Um, so when you're a self-represented litigant and you're going up against that kind of acumen and that kind of money, because the folks that are doing harm to these people in the county and in the states, when they go to court, when you take them to court, they then get to use the taxpayers' money to get the best representation legally that money can buy. So you can imagine that's a huge obstacle when you're just a regular person trying to navigate this. But that's the challenge that we have taken up. And there is a platoon size element of us that are doing pretty darn good, all things considered. So today we're going to revisit that over at the Supreme Court and kind of delve into it. We'll start with the prayer. Obviously, I've experienced some amazing miracles along this way, and that has been a source of fuel to stay in the fight. As has my meeting parents and people that have resolve that I would compare to that of soldiers. Um, Most soldiers deploy, they swear an oath to defend the Constitution. They're kept away from their families because they deploy or they're out in the field. And there's parents that are now doing that and they're fighting relentlessly. Um, but the war that is being fought is for their constitutional rights that it should have never been stripped from them to begin with in many circumstances. Um, the Supreme Court has upheld the 14th Amendment and the First Amendment, the bond to the parents and their child, and it's being cast aside. And there's so many good folks out there across the country that are doing their best. They're giving it their all to try to make a change to in this harm. And so I hope y'all will join us a little bit later. We're going to be going live. We're just down the way right here from the Capitol, and we'll delve into this. So I have filed to the United States Supreme Court to address an affront to justice in the state of California, specifically in the county of Napa, where for judicial officers, state judicial officers, and other state officers and county associate or employees have willfully, intentionally provided material support to FTOs. And that is the ask to the United States Supreme Court, asserting 18 USC 2339 Bravo as that's the driving force. Case would be Holder versus humanitarian aid, to align those two, which that case was brought before the Supreme Court, and the Supreme Court had determined that yes, the First Amendment does not protect you when you're providing material support to what's called FTOs. And they left it open as to whether to determine state actors and officials who could potentially be abusing their powers. Would that be characterized as providing material support to FTOs? And in this circumstance, there's two litigants, myself and somebody else, and I was on the DOJ side. The other person was on the FTO side. And that individual that was on the FTO side now works for the county, and with and for these individuals that are these state actors that are now all respondents in the Washington, D.C. action, as well as the Eastern District of Virginia, and subjects of that request to the United States Supreme Court. Justice John Roberts and the others were involved in that that Holder versus humanitarian aid case, and they left it open to wait for a case to come along that would provide them the opportunity or the vehicle to make that assertion or decision and to opine as to whether or not state actors abusing the machinery of justice can be determined to be providing material support to FTOs. But in this circumstance, it's a no-brainer because the state actors were duly informed that what they were doing was exactly that. So normally you have to they have to be aware of it, that what they're doing. And so these folks were made aware, yet they continued to press forward. And then when they realized they faced a complex liability, they then turned the machinery of justice into a weapon against the individual who was asserting federal supremacy and federal law, which then creates another legal conundrum because that's I think 18 USC 1512 or 1513, where you're, obstruction of justice, retaliation against a witness. There's a myriad of crimes relative to that. And there's this complex conspiracy that has resulted in the county of Napa, where the very people that were asked to protect then turned the machinery against the person asking for the reasonable protections and just completely press federal supremacy and the federal laws to the side because they wanted to conceal their complex liability. And they've continued to do so. They've came after me relentlessly because the clock is ticking on the statutes of limitation. And if a county doesn't do a background check on somebody, but they send that person out to go discharge a duty, but and then that duty does harm to people, well, the county of Napa has an insurance policy that won't pay out on that. So these people that have been harmed would not be given redress, and not from the insurance of Napa. It would fall to the county itself, which the county has been held accountable multiple times for racism and for the Casey Slusher case where there was loss of life. It was the largest settlement in Napa history. I think it was $5 million, and they were determined to be um, incompetent in that or responsible in some kind of way. And the prosecutor who in that case is now the judge in this circumstance, who's now cited in the habeas corpus that sits before the U.S. District Court in D.C. and the writ of mandamus with the United States Department of Justice and the D.C. Court. That's now the judge. And I recently filed a recusal motion. She refused to let me go in camera. There's a whole bunch of stuff that's been going down. That's been brought before the honorable court in DC and before the FBI and the DOJ relative to these state actors that are they're rogue and they're going off the rails. So everything is brought before the honorable court, and they're trying to keep everything from the public because if the public don't know that they sent somebody out there that should not have been able to take people's children, like Melissa Kelly. The fact that they were putting her on the stand and taking people's rights away based on Melissa Kelly's testimony when she was fired from the Berkeley Police Department for falsifying a 5150 against somebody because she was angry at the person, right? But yet Napa County then hires her and has her testifying in court to infringe upon people's rights. This other individual they sent out and took people's parental rights without doing a proper background check to understand that person had their parental rights suspended because of their conduct in San Diego County. And so they're trying to hide this. So the clock keeps ticking on statutes of limitation so that people who could and should want to hold them accountable, the clock is going to tick, and they're trying to run it down so that people who may be out there and say, hey, hold on, wait a second. You sent this person to suspend my parental rights when that person's parental rights were suspended because they were trafficking for the cartel against the United States. Yeah, that's the insanity of the circumstance. What's going on right now. And the judges have willfully, intentionally played their part in it. We got judges that are rogue and off the chain over here participating in federal crimes in the courtroom. They've been observed. It's been brought before the United States Department of Justice, and we shall rock and roll. But we started off over there with the interview with Audra Morgan and Eye of the Storm. And I hope you'll join us today because we got a whole lot to go over and to cover when we're going to talk about this and explain what an FTO is, what's the connection between FTOs, the executive order that went into place, and the difference between an executive order and a law, which the executive order is not law, but it did add people to what is a law. 18 USC 2339 Bravo is a law. It's an enforceable law, and these folks are in violation of it by their conduct. So I hope y'all will join us in a little bit. We're going to be tapping in over there. There's a lot going on. We're in Washington, D.C., folks.